Lecture 4: Legal Issues for Entrepreneur.
What this course would include. इस कोर्स में आपको 20 वीडियो लेसन्स हैं और हर वीडियो लेसन के साथ एक आपको केस स्टडी भी दी गई है जिससे आप और अच्छे से उस टॉपिक को समझ पाएंगे।
Contents for Session 4. In this session, we will discuss intellectual property rights and legal issues to consider when starting your business. Introduction. The basic legal steps before doing business are: first, handling issue with your prior employees, choosing a company name, filing all the documents with the secretary of the chosen state, paying all the required fees with the chosen state, working on the capital structuring of the equity, drafting employee agreement, legal document for incentive stock options. In continuation with the previous slide, we all know that we need a legal help in the following areas: incorporations, copyrights, trademarks, patents, contracts and agreements, personal needs of the venture team, real estates and leasing agreements, employee stock ownership plans, franchising and licensing, formal litigation, delinquent accounts, liability protection, merge and acquisition, employee benefit plans, tax planning, and review government and regulatory reporting. Now let's discuss intellectual property right. Intellectual property refers to the creation of mind, innovations, literacy, and artists' work and symbol, name, images, and design used in commerce. Rights related to copyright include those of performing artists in their performances, producers of phonograms in their recordings, and those of broadcasters in their radio and television programs. First, the term intellectual property reflects the idea that its subject matter is the product of the mind or the intellect. These could be in form of patents, trademark, geographical indications, industrial design, layout designs of integrated circuits, plant variety protection and copyright. Intellectual property protected through law, like any other form of property, can be a matter of trade. That is, it can be owned, sold, or bought. The major features that distinguish it from others form are intangibility and non-execution by consumption. Third, intellectual property is the foundation of knowledge-based economy. It is for all the sector of economy and is increasing become important for ensuring competitiveness of the enterprise. Let's discuss intellectual property rights. Now, what is intellectual property? Intellectual property refers to creation of the mind, inventions, literacy, and symbols, name, images, and design used in commerce. Following are various components of intellectual property right, that is, copyright, trademark, trade secrets, and patents. Let's discuss these components in detail. First is copyright, the legal right to be the only person who may print, copy, perform a piece of original work such as a book, a song, or a computer program. Copyright is a type of intellectual property that protects original work of authorship as soon as an author fixes the work in a tangible form of expression. Under Section 13 of the Copyright Act 1957, copyright protection is confirmed on literacy work, dramatic work, musical work, artist work, films, and sound recording. For example, books, computer programs are protected under the Act as literacy work. Now let's move to the second component, that is trademark. A trademark is a special symbol, design, or name that a company puts on its product and that cannot be used by any other company. The Trademark Registry was established in India in 1940. Presently, it administers the Trademarks Act 1999 and the rules thereunder. It acts as a resource and information center and is facilitator in matters related to trademarks in the country. The main objective of the Trademark Act 1999 is to register trademarks applied for in the country, to provide the better protection of trademarks for goods and services, to prevent fraudulent use of the marks. In continuation with the previous slide, let's discuss copyright and trademark law. Copyright and trademark law forms an important part of intellectual property rights. Copyrights give long-lasting rights pertaining to literacy, architects, and musical creation, whereas trademarks are protection against imitation as long at least as they continue to be employed in trade. According to the Indian legislation governing intellectual property rights, all architects, literacy, musical, dramatic work are come within the purview of copyright. But if it has to be used in contest with goods, that a certificate concerning the same has to be obtained from the Register of Trademark. Thus, though they are governed by different laws, they are two sides of same coin. Let's move to the third component, that is trade secrets. Trade secrets is a piece of information, for example, about how a particular product is made that is known only to the company that make it. Trade secret is a formula, process, device, or other business information that is kept confidential to maintain an advantage over competitors. It is an information including a formula, pattern, compilation, program, device, method, technique, or process that first derive independent economic value, accrual, or potential from not being generally known or readily ascertainable by others who can obtain economic value from its disclosure or use, and second is the subject of reasonable efforts under the circumstance to maintain its secrecy. So we can say that trade secret is an effective tool to protect intellectual property right of an entrepreneur. Now let's discuss this with case study of Coca-Cola Company. Coca-Cola moves secret formula to build new vault in Atlanta since its creation 125 years ago. Coca-Cola has kept its formula a jealousy guaranteed trade secret. Coca-Cola has moved the secret formula for its international brand name soft drinks to an impressively high security looking vault in Atlanta. On Thursday, the company released photo of the formula's new home as a part of a promotional campaign for its shrine-like World of Coca-Cola Museum, where the recipe is now entombed in a massive steel vault. Since its creation 125 years ago,
Coca-Cola has kept its formula a jealously guaranteed trade secret, spinning elaborate marketing mythologies about the ingredients and the people who know them. For example, until this week, the only official written copy was supposedly held under lock and key in a bank vault. Only two persons at any given time are supposed to know the secret formula, and the same two persons are prohibited for taking the same plan in the event. It crashes and the trade secrets are taken to the grave. According to the Beverage Digest, the secret formula was moved from a Suntruck Bank vault in Atlanta. Earlier this year, weekly radio show The American Life out of Chicago claimed it has decoded the recipe after the finding the original recipe burned quietly in the back papers of the Atlanta Journal-Constitution, 1979, a publication dedicated to the birthplace of its caramel-colored soda pop. Among the secret ingredients are coriander, nutmeg, orange, and lemon oil. So this is the case study of Coca-Cola. Now let's discuss our fourth and last component, that is patent. A patent is an exclusive right granted for an intervention. In other words, a patent is an exclusive right to a product or a process that generally provides a new way of doing something or offer a new technical solution to a problem. Now, reference to the previous slide, let's discuss this slide too. Patent right varies from country to country. In India, the law which governs patent right is Indian Patent Act 1970. This act, that is Indian Patent Act 1970, grants exclusive right to the inventor for his invention for limited period of time. Generally, 20 years time has been granted to the patent holder, but in case of innovations relating to manufacturing of product, food or drugs or medicine, it is for 7 years from the date of patent. There is certain legal procedures which need to be followed within order to register as patent. There are survival attorneys helping inventors in patent registration by providing them the best well-informed knowledge. In India, patent registration can be filed individually or jointly. In case of deceased inventors, this can be done through legal representative on the behalf of him. All the required documents need to be filled along with the application form. Only after verification, registration certificate is provided to the applicant. Now let's discuss the patent law in India. The entire patent system and the patent law in India are governed by the Superintendence of Journal Controller of Design Patent, Landmark Patent and by geographical indication. This office of Journal Controller run under Department of Industrial Promotion and Policy. There are 4 patent offices in India. Head office is located in Kolkata and other offices are located in Delhi, China and Mumbai. The examiners of each patent office have to release their work according to the direction of controllers. Patent law is complex, which is essential to obtain the services of an attorney who specialized in patent law.
Patent law is one of the fastest growing fields of law which deals with issues surrounding the protection of ideas. By protecting the rights of the investor, the government can be sure that people will continue to think of unique and new ideas to share with the world. Patent law of India has the following main features which decide whether a patent will be granted or not. First, the object. The object of patent law in India is to encourage significant research, new technology, and industrial progresses. Second, inventive steps. The fundamental principle of patent law is granted only for an invention. Now let's discuss intellectual property rights in India. Among the agreements of WTO, trade-related intellectual property rights is of special significance to the entrepreneurs. India has modified its law on intellectual property to be compliant with WTO provisions. However, developed countries have still apprehensions about enforcement of intellectual property laws. The trademark registry is also proposed to be further strengthened and modernization. A project for modernization was earlier implemented during 1993 to 1996. Further strengthening of the registry is being taken up at a cost of 86 million. The main thrust now is to strengthen the infrastructure of the trademark registry and the earlier removal of backlogs of pending applications, transfer of records to CD-ROMs, re-engineering of work progresses, appointment of additional examiners, etc. As regards the aspect enforcement, Indian enforcement agencies are now working very effectively, and there has been a notable decline in the level of piracy in India, in addition to intensifying raids against copyright infringers. The government has taken a number of measures to strengthen the enforcement of copyright law. Now let's discuss the legal issues to consider when starting your business. There are a multitude of legal issues to think about when it comes to starting your business. Everything from your business name to the structure to its operation has legal implications. What follow is sampling of some of the legal concerns you may want to address with your attorney before your start of your business. Now let's discuss legal issues to consider when starting your business. First, business name. Second, business structure. Third, business licenses. Fourth, non-disclosure agreements. Fifth, zoning. Now let's discuss one by one in detail. First is business name. You will make sure that the business name you plan to use it is not already used by some other organization or any business. You can do this by doing a name search with the appropriate state agency, which is usually the office of the Secretary of State. If your chosen name is not already used, you can reserve it with the Secretary of State's office for a period of time about 120 days while you prepare your article of incorporation, article of organization, or a partnership agreement. Second is business structure. You will need to decide which business structure best suits your business. Your business could be structured as sole proprietorship, partnership, limited partnership, corporation, or limited liability company. To decide what form is best, you will need to consider liability issues associated with your business and which form will provide the best tax structure for your business. Third is business licenses. Depending on what type of business you plan to engage in, you may need a variety of licenses or permits. Moving to the fourth point, that is non-disclosure agreements. If you will be setting up financing for your business or entering into contacts with suppliers, you should consider non-disclosure agreement. The more confidential information your business plan contains, the more important these agreements are. Last point is zoning. When you are selecting the location for your business, you will need to make sure it is properly zoned for the type of business you plan to operate. It is not okay to just assume that if your business is of the same type as the one that is currently there, the zoning is appropriate. Zoning may have changed while the other businesses were operating, and that business might have been provided an exemption that won't be provided to yours.
Students of Amritsar Law College is going to perform a short play which is going to be emphasized on the valid agreements of a contract, and there must be presence of two parties, and that agreement must be enforceable in the court of law. So, the following scene is of a courtroom where we will see how little negligence on part of a party is executed and is detrimental to their interest. So, we have taken example of non-disclosure agreement between a company and its employees.
Messrs. Surat Textile versus Raman Arora.
Are both the parties ready to present their final arguments?
Yes, Your Honor.
The counsel for plaintiff may begin.
Your Lordship, this is a very simple and straightforward case of breach of non-disclosure agreement between my client and accused. The accused must be punished for the breach of non-disclosure agreement which he has duly signed and executed at the time of employment at the company. If we refer the clause 7A of this agreement, it is mentioned clearly that if employee leaks any material information about the production process of the company, then company shall reserve the right to terminate him on finding of such event, further sue him for the monetary compensation of the company.
So, as the material you have provided, it clearly says that any material information regarding the company and its functioning must not be disclosed to the employees. Is it true?
Yes.
Then my question to your counsel is that do you think it's sufficient enough? You said in your argument that it has mentioned quite unambiguously that you don't see the apparent ambiguity regarding the scope of non-disclosure clause. Where does this agreement define the contents that you have said? Material information, and all. Does the company refer the material information that you have provided in your account as deemed to be confidential? If so, then doesn't this make this agreement full of ambiguities? Anyways, I would like to hear now the defendant.
Your Lordship, as per the admitted facts in the plaintiff has alleged that my client has disclosed material information regarding their production process. Now, I would like to bring it to your notice, Lordship, that nowhere in the agreement, let alone clause 7A, has it been mentioned that what information is material and what is immaterial. And further, there is no definition of what they may even consider deemed to be confidential. It is a matter of evidence, Your Lordship, that the particular agreement is full of ambiguities and lacunae. Further, I have a very simple question for the plaintiff, that how did they come to know about the alleged leak of information if it has been made oral? Won't it be hearsay? Moreover, I would also like to bring it to your notice that my client has been working in the accounting department of the company for 3 years as per the records of the company, and also he had bachelor's degree in commerce. Won't it be impossible for my client to have that much material information regarding their production process? The story seems too far-fetched to believe. I will close my argument with a humble request that there is no evidence proved which implicates my client in any breach of a non-disclosure agreement. and further, the presence of large ambiguities have been evident in their agreement. So, on the basis of arguments, evidence, and in the interest of equity, justice, and fair play, I would request to your Lordship that kindly acquit my client of all the charges of the breach of non-disclosure agreement, and he must be given back his employment as he is the sole owner of his family.
After hearing from both parties and carefully examining the evidences particularly, it is quite evident that there exist ambiguities in the disputed clause 7A, and it does not clearly and unambiguously define the scope of confidential information which was not supposed to be disclosed. On the ground of such ambiguity, the lack of any foolproof evidence against the accused Raman Arora, this court considers him innocent and acquits him against any monetary or any other punishment, and the court further directs the company to hire him with the same salary and other perks and privileges to maintain the status quo. This case is decided with no directions as to cost.
So viewers, did you see how a minute mistake in due diligence and in constructing the non-disclosure agreement have proved costly to the company? Now even if that employee was wrong and had committed the breach, the company would be left with no remedies to prevent such breach because of the ambiguous agreement. That is why it is must to have the document drafted by a well-qualified and experienced corporate nitty-gritty of these agreements, so that the company must protect its privileged information or any other right for that matter. Now let me quickly brief you about the non-disclosure agreements and the key elements and precautions that must be taken before executing such agreements. In business, there are numerous instances in which you may want to share confidential information and you provide them and not use it to your detriment. One common way to protect the secrecy of confidential information given to another party is through the use of the non-disclosure agreement, which is sometimes also referred to as confidentiality agreement or non-disclosure agreements. Now, my fellow mate will throw some light on the key elements of non-disclosure agreements.
The key elements of non-disclosure agreements are: non-disclosure agreements do not have to be long and complicated. In fact, the good ones usually don't run more than few pages long. The key elements of non-disclosure agreements: identification of parties, definition of what is deemed to be confidential, the scope of confidentiality obligations by the receiving party, the exclusion from confidential treatment, the term of the agreement. What is deemed confidential? This section of NDA, which is non-disclosed agreements, deals with defining what confidential information means. Is it any information? Is it information that is only marked in writing as confidential? Can oral information conveyed be deemed confidential? All this must be expressed in clear and ambiguous words.
I would like to conclude by saying that forming the non-disclosure agreement in entrepreneurship is a major legal issue that may become a bane instead of a boon for the party executing the agreement if it had not been properly and precisely worded. So, our message to the young entrepreneurs is that they should be very diligent in executing their agreement so that they don't lose their most valuable assets just because of mere technicality.